Please be seated. We have two cases on the docket scheduled for oral arguments this afternoon. Our first case is Philip Miller versus Weissner Security Services Incorporated. You may approach, counsel.
Thank you, Justice.
We'll allocate 20 minutes per side for the oral argument. Would you like to reserve some time for rebuttal, counsel?
5 minutes for rebuttal, please.
So noted, Madam Clerk. You may continue, counsel.
If I go over, I'll just reserve less, that's all. So thank you. May it please the court, my name's Ware Cornell. I'm from Weston, Florida, and I represent a guy from Pensacola. And we owe all of this to Zoom, I believe. But the bottom line is Mr. Miller was what was called a Maritime Transportation Security Officer at the Port of Pensacola. And Mr. Miller's obligation was to control the flow of commerce in both foreign and interstate that existed at the port. It was a position required by federal law, and he is thus subject to Section 1 of the Federal Arbitration Act. His employment contract with Weissner Securities states that this will be governed by the Federal Arbitration Act. The Supreme Court has been deciding cases recently. Most recent are Bissonnette, and then about 10 days ago, Flowers Food. And those cases make it clear that what happens to invoke the exemption for those engaged in facilitating commerce don't have to be truck drivers. They don't have to be people who do anything other than whose job facilitates it.
Well, let's go to the language of the statute, which discusses engaging in interstate commerce. And I do appreciate counsel's helpful notice of supplemental authority on the Flowers Food case, where the Supreme Court, made clear that the statute speaks in terms of transportation workers engaged in interstate commerce, and the court was careful to draw a contrast between workers who are affecting or are involved in interstate commerce. Why isn't your client's role more of that, affecting, facilitating, as you've, used that term, rather than engaged in?
When I think about this, Judge Ray, I think about the analogy that we often hear about baseball umpires. It's not a ball or a strike till someone calls it. And what Mr. Miller is doing at that port is deciding who comes in and who doesn't. And we do that for a number of reasons. 9/11 has a lot to do with it, but it is still a function of commerce. If driving the last mile of a bread truck into a port is someone who's engaged in commerce, then someone who has the ability to keep the bread truck out because he's not properly credentialed, or to make sure that he's supervised and safe while he's on the grounds of the port, then that person is engaged in commerce. This is a federally required duty, and he is doing it. And he's not, we talk about, well, he's just a security guard. He's not. He inspects cargo.
Counsel, let me ask you
Yes.
more
Yes,
about that, because your brief uses language like cargo inspection, clearance, shipment clearance, security clearance. The declaration uses words checked in.
Yep.
Does the record give us any more indication of what checked in means in these contexts?
Well, the record would consist of the declaration. We don't have defense declarations as to why it's not interstate commerce. What we have is, this argument that he's a security guard, but he's doing much more. It says he inspected GE engines bound in interstate commerce. That is not what a security guard does. This is what somebody does who is controlling the existence of commerce. And that, to me, is pretty clear. If you look at Flowers Foods, driving a bread truck in would seem to most of us not to be really being engaged in commerce. But what the court's really saying is you don't have to drive a truck, you don't have to touch the goods, you just have to be doing something that the language, I guess, is engaging in commerce, and that is what he's doing.
Well, let's explore that
Yes,
a little
Judge.
bit. And I just want to go back to the recent discussion by the Supreme Court on, again, drawing the distinction between engaging in versus affecting or involving. And so how are courts to draw that line? We can think of air traffic controllers, certainly control when planes land. We can, the people who fuel the gas for the trucks. The trucks aren't going to leave the port unless they're fueled up. So are they transportation workers? How do we draw that line?
Well, you don't have to draw that line here because that would be hypothetical. You have to draw it in respect to what Mr. Miller's actual job duties were.
That is true, of course, but we're always interested in the implications of our ruling, and you're no doubt asking us to extend that line. There has not been a single case cited in any of the briefs where someone who's been in the class of workers that your client is in has been found to be an exempt worker under Section 1.
And that's true. And the reason for that is that this is the first time, I guess, that anybody has challenged whether or not someone who is a maritime security transportation officer is engaged in commerce. I mean, there's lots of job duties that happen at the port, some of them which would be engaged in commerce and some of them would not. This one is. You don't get to, commerce doesn't occur, sort of like the baseball umpire I was talking about, until the umpire calls it, until the security officer says it's free to go. And that is interstate commerce. That's foreign commerce. And consequently, I believe that, Flowers, I don't think the Supreme Court's going to take, every case that comes before it. But if you look at Flowers, it is a very broad category. And someone who works in an office at the port may or may not be engaged in commerce.
Well, why not? Under your reasoning, why not? I mean, if someone's in the office and their signature is necessary for, a bill of, I don't want to use the wrong.
I think bill of lading.
Bill of
might
lading
be.
is probably the right term, but they have to sign it in order for those goods to leave. Are they now transportation workers that are exempt under Section 1?
They could be, but it all depends on what the underlying facts of the situation are. I would say that we really have, this came up to the court on a motion, the trial court, on a motion to compel arbitration. There was no discovery, there was no anything. The only thing we have in the record is Mr. Miller's declaration. And the court said, well, that's conclusory. Well, maybe some parts are, but the jurisprudence in this state says just because something is conclusory doesn't mean everything in it is conclusory. And if you look at this, at the very worst, it ought to go back for an evidentiary hearing on this, because we've never heard from the security company, from the employer, as to why this isn't, other than the fact that they say, well, security guards in general aren't engaged in commerce. Well,
Did they have a burden, though? I mean, you're the ones asserting an exemption from arbitration, your client, correct?
I am the one asserting it. On the other hand, they've just put in a contract, and they wrote the contract. It said under the Federal Arbitration Act, Section 1 is there. We obviously, from the moment that it was raised, we objected to it and said he's exempt. This is before Flowers was decided, but after Bissonnette. And Bissonnette was what guided us. If you look at the transcript, we said to the judge, there's another case coming. We don't know when it'll be decided, but it was Flowers Foods and was decided 11 days ago. The bottom line, I think, Judge Ray, is that the Supreme Court cases focus on the kind of work that's employed. And maybe it is, in view of this new case, that your order ought to be to send it back and see what the factual record is before you write some broad description, one way or the other, saying that this is or is not in commerce without a factual record being really developed. Because I think Judge Rowe actually asked me that question, and I honestly don't think there is a factual record that certainly could deal with some of the subtleties of both Bissonnette and Flowers Foods. And consequently, I think that that's there. Miller's work was clearly necessary for commercial activity, foreign and interstate, to occur. And that seems to me, under both Flowers and Bissonnette, an absolutely critical situation. And something that seems to be, because in 1925, when the Federal Arbitration Act was enacted, we didn't have, TWIC cards, and we didn't have the kinds of problems that developed in this century. And the courts have looked at it and said, we're going to take a very broad view of who's exempt from this. And that's what they did.
I think that's right, but at the same time, and they reaffirmed this, just 11 days ago, as you said, that it's not just necessary; it's direct, active role in moving goods across borders. And they cited their prior decision, and they said they reaffirm those factors today.
Sure.
Right, so you certainly, I think the necessary part you've shown, but the direct and active role in moving goods across borders, how does the record here demonstrate that Mr. Miller was directly and actively helping to move goods across borders?
You had to inspect GE turbines. That's pretty direct. I mean, that's not, like looking at a load of cargo. That was part of his job. He had to do that. He had to make sure that anybody entering that port held the proper identification or was secure. Went with a guard to somewhere.
On that point, though, how is that any different than just a security clearance function as opposed to a transportation function?
Because if it's not a security clearance to have to inspect GE turbines. I mean, I don't personally know how to inspect one. I think most security guards wouldn't. I don't think that would be part of their duties. When you think of security guards, you think about, people at condominiums and maybe out in our rest areas after what happened many years ago on our turnpike and on 95, but this is not what he did. He was a necessary cog. He was required by law to have a TWIC identification card and clearance, and he was required by law to keep people out who did not have that. He was required by law to make sure that everything entering and leaving the port was properly documented, which means before it went out into the stream of commerce, be it on the highways on exiting the port or on the shipping lanes upon maritime exit. So I would say that that's the critical difference between a regular old security guard and what he did. If it was a security guard, let's say you had, I practice this in South Florida, and we have a lot of cruise ships, and let's say Carnival has an office at the port, and there's a guy whose job it is to check people in who want to see, managers from Carnival. Is that aiding in commerce? I don't think so. But they're security guards, and they're there for a reason. But he's there for a very specific governmental, federal governmental created position, and that is, for protection. And that's
So,
aiding
Counsel,
in commerce.
it's your position that these functions you just mentioned that Mr. Miller engaged in were sufficient to show a direct, necessary, and active role in moving goods across state borders?
Absolutely. I don't think there's any question about any of that. For this position, and he did it. There's other positions that it might be questionable, but not this one. But on the other hand, you could develop a record and see what it is before there. I mean, once we get sent to arbitration, the only courts we have to decide things are, circuit courts and district courts of appeal. So,
Thank you, Counsel.
okay, thank you, Your Honor.
May it please the court, Ryan Barnett for Weiser Security Services. The question before the panel truly is one about expansion, and we would respectfully submit that what is sought here by the appellant is a significant departure from the manner in which Section 1 has been interpreted by courts, how it's been applied by courts, and we would urge that there are several key guideposts as you consider this issue. The first being, if you look at the manner in which this has been addressed by the courts, and there's been a development, a history here, I would say largely beginning with Circuit City, flowing into Saxon, I think would be another very, very helpful decision. I think Perez is helpful in terms of its framework, not its precedential value, but for its framework. The federal magistrate's decision in the Burgonia case. And I'm going to talk about the Flowers case and Bissonnette in a moment, but I'd say it would urge the court to consider those primary. I'm going to come to those in a moment. Secondly, this question about TWIC is, I would argue, really it's a distraction. The question about access is not an issue that's really been addressed by any of these courts that have looked at this issue. And the third kind of guiding principle that I would urge the court to consider is what is the limiting impact here in terms of practical application. So if the court accepts the argument that is made by the appellant, the door is opened, and virtually anyone who has any tangential connection to the transportation industry falls within this exception to Section 1, which has simply just not been the manner in which that decision, that statute has applied. So turning to the cases, so I would urge the court, if you look closely to Bissonnette and to Flowers, the effect is really fairly limited. So in particular with regard to Flowers, the court was looking at the question of, is it interstate commerce if a driver goes intrastate first, only stays intrastate before the goods go on into the interstate process. The reasoning is helpful, but those are the facts of that case. Bissonnette simply tells us that one doesn't need to be in the transportation industry in order to be a transportation worker. As you'll recall, those are bread truck drivers in essence. And so the court says, hey, just because they work for bread trucks, bread company, doesn't mean that they can't be transportation workers. So if you look at those holdings, they are limited. I think the case that is very helpful for us here is Saxon, and we see the aviation industry, be an analogous setting for where these cases come from, because that's another similar port-like environment where goods, people are moving from one environment to the other. And I have to concede, I agree with counsel that the court has not announced directly that there's a bright line test about hands-on movement of those goods. But the effect of the rulings and the rationale from all these decisions, I would argue, is fairly clear. If you look at Saxon, if you look at Perez, if you look at Burgonia, all of these cases, in those cases, Burgonia and Perez involved security personnel who were involved in the ancillary process of moving passengers in the airport. And we see the court focus on the fact that they are involved in that process, but they are not directly involved and engaged in moving goods and services or people in interstate commerce. The other thing I think is very helpful, if you look at the court really goes through a pretty interesting discussion in Saxton about the language, the very language of the Federal Arbitration Act. It's almost 100 years old, but it focuses on workers as opposed to employees, which I thought was a fascinating distinction. But in terms of using statutory construction, the court really focuses on the fact that workers, seamen, one can be a maritime worker and not be a seaman, working on the deck of a ship moving goods. One could be a railroad worker and not necessarily fit that rubric. So if you look at the language there, the court focuses on the worker. And the worker, in the decisions that have come to us so far, is really the one who's moving goods. So in Saxton, which I think, again, is so helpful, we are dealing with a baggage supervisor who handles material as a working supervisor and putting them on the vessels or the aircraft. Not required to be the pilot, but she is directly involved in that case and getting things onto the aircraft, and therefore she falls under the exemption of Section 1. But that is simply not the case here. This individual, the security worker, does an important role. We're not in any way demeaning his job as being unimportant. Judge Lewis, did you have a question?
No, go ahead.
Okay, I'm sorry. You look like you're about that. I didn't want to interrupt you. But in this case, he is not, in the declaration, does not give us any indication that he's putting his hands on materials. He's putting his hands on goods. You could, and if we did a hypothetical, Judge Rowe, we could change this situation, and perhaps if the declaration says that he is physically manipulating goods or he's some way more directly involved, the facts could be different.
Well, let me follow up on that question, because it goes to the question I asked opposing counsel is, whose responsibility is it to make that record? I mean, we have very limited description about what this worker's role is. And without that additional context, I think it's hard for us to determine whether or not he falls within the exemption. So whose responsibility was that to make the record, or do we have a sufficient record if not?
I would Judge Ray, I would argue that there is a sufficient record. In this case, I think, and I don't believe that issue has really been addressed in the briefs. And I appreciate that it's a question and a concern for the court to reach the right decision here. But the record that was promulgated in this case consists of a declaration that was put forth by the plaintiff, by the appellant. In this case, the appellee, the employer, there really was no reason to counteract or argue that declaration was inaccurate. We don't dispute that what he said there is truthful to the extent that it makes factual allegations. Much of the allegation is conclusory. I work in interstate commerce. Well, what are the facts around that? The appellant in this case had the burden, I would submit, to present a sufficient declaration to perhaps raise an issue. And I think if I recall, there was no argument made at the trial court level that, Judge, we need some limited discovery here. There was no request for that. The argument was, here's the declaration. We've got some cases, Judge. We think there's a sufficient basis for you to make your ruling. So,
and to follow up on that, there's nothing that would have prohibited seeking an evidentiary hearing on any of the issues raised in the declaration.
Correct, Judge Rowe, and that was never asked. And would we be at a different posture? Perhaps, but that's not the basis for the appeal. It's not been argued in the briefs. And I would submit respectfully that the record is sufficient. It may not be the record that the appellant likes, but the fact of the matter is that there are not factual allegations that track with any of the decisions that we've seen handed down on this issue.
I'd like to engage a little bit with some of the circuit decisions, and I think you would concede this is not as easy as the kind of just plain security guard janitor cases that some of the federal circuits have looked at previously. The interesting element in this case is that Mr. Miller wasn't simply security, he was also a gatekeeper. So he could stop or start the flow of goods by saying, look, this can't come in or that come in. And I don't know that there's a case on point that you've cited and maybe you're aware of, but doesn't that make a difference, this ability to stop or start the flow of commerce?
Judge Rhodes, good question. I think the most analogous example we have is the security gatekeepers, literally gatekeepers in Perez, in Bergonia. We have there very analogous situations. We have personnel who act as a gatekeeper in that setting. So rather than being in a port, we're in an airport. And somebody who comes up to that gate, the security personnel can say, your passport's no good, your ticket's not good, or we have a flag on you for whatever reason. So I think we have very analogous facts in those settings where the courts have said that's not enough. The gatekeeper role is not enough. And I can appreciate why intuitively it's it would seem like that might be the, you know, the basis. But if you look at those decisions, which are very, very similar, where we have gatekeepers, just their location is different. It's not at a port, it's at the gate before you board an aircraft. The courts have said that's not sufficient. That is not sufficient.
Well, let me follow up then, because the Supreme Court has reiterated now in Flowers that this, you know, what does it mean to be engaged in interstate commerce? It's direct, necessary, active role in moving goods across borders. So what is deficient here? I think you would agree that this is necessary, right?
Yes.
So is it not direct? Is it not active? Is it not moving goods? What's the problem with Mr. Miller's role here?
So I think if you look at to me, some of the most helpful language comes from Saxon. And the language used in Saxon, as I recall it, is essentially that they are so directly involved in the movement of goods as to be a part of it. In all of these cases, again, without a bright line test, but the effect being that the individuals who sought and were given exemption under Section 1 were directly involved with the goods. So they were handling the goods, they were moving them in some shape or form, they were on the aircraft or the ship or whatever the case may be. But in this case, I would submit that that would be a significant departure, a significant aggressive expansion of what that term has meant under the cases that have come before courts.
What about the aspects of his job that were more than just checking people in to make sure that they were properly permitted, but he checked in loads of concrete, he checked electric turbines. Does that not make it closer to a transportation worker than your average security guard?
Judge Ray, I would say, again, I would point us back to the aviation cases where the courts have said in very similar situations where we're talking about passengers, their belongings, the things that they're taking onto an aircraft. That role in and of itself does not avail them of the exemption under Section 1. So we don't have a case that addresses that. But I do think we have some helpful guidance from aviation cases, essentially, that have rejected that argument.
In what respect, though? I mean, that was with regard to passengers. So this is actually hands-on with the transportation equipment, as I understand it. So in what respect would that be different?
Well, I want to make sure I understand your question, Judge Ray. And in this case, I don't believe there is any allegation that Mr. Miller was hands-on with anything.
What about the checking in of the loads of concrete and checking electric turbines?
I don't read that. One I suppose could, but I don't think that under the circumstances there was a clear allegation that he was. I would say even if he had put his hands on products to examine them, so to speak, that's not engaging in the transportation. That's engaging in an ancillary role, which again the courts have looked at this ancillary question, which I think you have to really draw an intellectual line between what's an ancillary role and what's directly engaged. And you do have to look at each individual case on its own. But in this case, I don't believe that was sufficiently alleged.
And going back to Saxon, and I think Justice Thomas's opinion is helpful in that regard of his discussion of wharfage and that access to the port and carving that out from what the seamen are within the maritime context. So I think some of the language I think to engage with there is that the transportation workers must be actively engaged in transportation of goods across borders. So is that your best argument that, while there is a clearance of the goods, there is no aspect of Mr. Miller's job that involves transportation?
I would submit, Judge Rowe, that the courts have treated those as two different things. They have as I read the cases, they have not treated them interchangeably, that one is the same as the other. And the focus, and again, if you look at that language in Saxon, I think it's very helpful because it really focuses on the worker. The worker, and it goes through kind of a painful definition description there, but it really focuses on what the worker does as opposed to an employee, which really was not a distinction that it occurred to me until I looked at that closely. Part of that's because the language is dated. But the Arbitration Act has treated the two as two separate things. And those ancillary roles and all the courts that have looked at it thus far have treated them differently, I would submit.
As previously noted, the trial court specifically found that he alleged that he checked electric turbines from GE for shipment by sea.
Yes, sir.
That is an allegation.
Yes, sir.
Now, why is that not sufficient to show a direct, necessary, and active role in moving goods across borders?
Judge Lewis, I think the simple fact of checking something is not the rubric that the courts have used to establish that that is directly engaged in interstate or international commerce. One could theorize that it could be in certain circumstances, but in this case, and if we look at these decisions, again, checking passengers, and if you look at these aviation decisions, we're talking about also checking baggage, other things that might go on that aircraft. The court has not treated that as directly engaged in interstate commerce. Up to this point, it has not been treated that way. Are there any other questions that I can answer? I do want to reiterate one last thing to the panel. Again, from a practical standpoint, we put this out quickly in our brief, but I think it is worth mentioning again. This was a situation where Mr. Miller had the ability to opt out of this arbitration agreement. He didn't. So, this was not and there were some of the decisions that talk about adhesion contracts. I think that's even mentioned some of the more recent decisions, as an ancillary issue. This was not an adhesion situation. He had the ability to opt out of this contract. He didn't do so, and we respectfully ask the panel to uphold the decision of the trial court.
Thank you, counsel.
Yes, sir.
I think when you look at the two cases that counsel suggest, which are Perez and Saxon, what you see immediately is that those cases predate Bissett and Flowers Foods. And you really can't say that those cases would be decided the same way today, because you don't know. And he doesn't know either. But the last word on this is Flowers Foods, and it doesn't require that you touch it. It doesn't require that you drive a truck. It just requires that you are it's direct and necessary for the transport, for commerce. And
Let me make
is.
sure I understand your argument. Are you suggesting that Flowers Food in any way undermine the holding or move the court away from Saxon? I mean, they quote Saxon several times in the opinion without any kind of limiting language.
Well, as I understand it, it's not their obligation to say to the 7th Circuit or the 11th Circuit or the 1st Circuit, we disapprove of this unless there's a conflict, just sort of like we do here with district courts of appeal. But what I do think is that there's nothing in Flowers Foods that says that you look at anything other than what the job is. And as to whether or not we raised it before doesn't necessarily mean that we knew how this was going to be decided and what the court was going to say and what the standards are. And the standards, at worst, the standards have changed.
Well, counsel, you would agree that in Flowers, the worker was actively involved in moving goods, not necessarily across state lines.
Correct. I would. And Mr. Miller was actively involved in making sure that goods moved in both interstate and foreign commerce when he served as a maritime security transportation official. That was his job. He wasn't, as I think we've all agreed now, he wasn't just a security guard. He was doing something else, and his job was more than that. And I think at worst, we need to go back and develop a record, and I think at best, and I think it supports, is that under Bissonnette and under Flowers Foods, that the court below's order should be reversed, and we proceed in the circuit court.
Did you preserve that argument below?
I did not.
You did not.
I did not. I didn't know what Flowers was going to say. I knew it was coming, but I didn't know what it was going to say, Judge Ray. Is there anything else? Thank you all very much. Appreciate it.
And thank you, counsels, for your respective oral arguments.